Tere kõigile! Üle 5 aasta ei ole meie riigis ilmselt nii suurt IIZI kindlustuse üritust olnud. Mul on hea meel, et meil on saalis nii palju inimesi ja veebis veel rohkem. Meie kui IIZI jaoks on ka esmakordne sellist hübriidüritust korraldada. Ma loodan, et te naudite neid esitlusi, mis meil on ja et teil tekib kas peale esitlusi või siis natukene hiljem ka päris palju küsimusi, nii et alati võtke meiega ühendust kas siis kohe siit platvormi teel. Kes tahab saalist küsida, andke käega märku, ma toon mikrofoni ja vastame hea meelega ka küsimustele. Today is so international. We have a couple of people here from Polaris and a colleague from Sorainen. So it's not only hybrid, it's like multilingual event also. So thank you all, and Norman, the floor is yours.
Ja, tere hommikust kõigile. Alustuseks siis hea meel on siin olla ja nagu juba Helen Sissejuhatuses ütles, et tänane selline seminar on üsna hübriidne, et osad inimesed on siin saalis, osad ja veel rohkem on üle veebi ja see hübriidsus on ka natuke selles keele osas, et kuna auditoorium on nagu eestikeelne, siis ma otsustasin, et ma enda ettekande teen eesti keeles, et pärast seda läheb see seminar edasi inglise keeles. Ja võib-olla nagu ikka sellistes asjades ja juristidel on kombeks, et tuleb algul teha selline full disclosure, et kes ma olen ja et mis mu enda huvid siin mängus on, et millega ma nagu tegelen. Jah, minu taust on see, et ma olen praegu advokaat, ma olen partner advokaadibüroo Sorainen. Ma kohe ütlen ära, et mina ei ole kindlustusjurist, et kindlustusõigusega ma olen üsna vähe elus kokku puutunud ja võib-olla eelkõige läbi nende vaidluste, kus siis üks või teine pool on kindlustatud, kes siis on saanud siis oma õigusabikulusid kindlustusabil katta. Aga minu tänane valdkond on siis advokaadibüroos vaidluste lahendamine ja üks selle vaidluste lahendamise alaosa siis on inglise keeles on selle nagu parem nagu nimi, et on corporate disputes, et need on siis need vaidlused, mis siis toimuvad tavaliselt mingi äriühingu sees, kas siis osanike vahel, ühingu ja juhatuse vahel. Ja seal sageli on seotud sellised nii tsiviilõiguslikult kui ka karistusõiguslikud probleemid, et siis kuidas kliente on vaja aidata siis nende mõlemaga. Ja kohe nagu sissejuhatavalt võiks nagu ära öelda seda, et need vaidlused on üsna eripärased mingis mõttes, võib-olla võrreldes teiste tsiviilasjade või tsiviilvaidlustega, et ma aegalt natuke iseloomustan neid nagu sellise nagu abielulahutustega, sarnaste vaidlustega, et kus võib-olla seni üsna usalduslikus suhtes olnud nagu pooled järsku tunnevad, et üks või teine pool on nagu usaldust petnud ja selline usalduse ja murdmise ja selline emotsionaalne komponent nendes vaidlustes on alati juures, mis teeb neid kahtlemata eripäraseks, aga ka keerukaks. Aga räägime siis täna põhimõtteliselt nendest probleemidest, mis siis juhatuse liiget võivad tabada tema ametis, kus siis see kindlustus võib aidata. Okei, veel üks selline full disclosure on see, et mul endal on see kindlustus, mitte küll advokaadibüroos, aga ühes teise ettevõttes, et ma enam-vähem tean, millest ma räägin. Just selles mõttes, mul ei ole küll kunagi seda vaja olnud, aga kindlus on ikkagi olemas südames. Nii, aga juhatuse liige ja tema nagu vastutus, mis teda siis saadab, et väga sageli mõeldakse niimoodi, et äriühingut asutada ja seda juhtida on ju väga selline respektaable, glamuurne väljakutse, et kes meist ei tahaks olla ettevõtja ja edukalt ettevõtet juhtida, aga mina oma töökoha peal ettevõtte juhtimine ja juhatuse liikmeks olemine on ikkagi selline teatud mõttes kõrgema riskiga valdkond. Et neid rõõmsaid hetki võib-olla mina oma töös nende juhtide laua peale väga palju ei näegi, et väga sageli on probleeme ja tegelikult need probleemid kasvavad sellest üles, et juhatuse liikmel on väga palju kohustusi tegelikult. Nii seaduse vaates kui ka loomulikult äri vaates ja ma olen lihtsalt siia slaidi peale need kokku pannud, et võib-olla ma siin selle slaidi peal olulisem on see pilt, mis ma siia juurde panin, on see, et minu jaoks see juhatuse liikme nii-öelda elukutse natuke meenutabki sellist kuristiku serval nii-öelda kõndimist pidevalt, et ja siis on hea, kui seal mingisugused sellised need käepidemed on nagu juures, et millest ikka vahest nagu saab kinni võtta nagu abi on ja kindlasti üks see kindlustus võiks olla üks see abivahend, mis vahest aitab, kui vaja on, et mitte siis kuristikku kukkuda. Ja mis on üks sellise juhatuse liikme vastutuse alus ja tema kohustus, mille õiguslikus vaates väga palju tuleb tegeleda, ongi see, et meie seadustes on siis kirjas, äriseadustikus eelkõige, et ettevõtte juhtorganid peavad siis käituma või nende käitumine peab olema siis vastavuses sellise hoolsus- ja lojaalsuskohustuse standardiga. See on üsna selline, ega seaduses seda täpselt rohkem nagu ei täpsusta, et kohtupraktika on siis seda täpsustanud, mida see siis tähendab, aga see tähendabki siis seda, et juhatuse liige peab tegutsema korraliku ettevõtte hoolsusega, majanduslikult kõige otstarbekamal viisil, heas usus ühingu huvides, mitte siis enda isikliku huvidesid taga ajades, olema piisavalt informeeritud, mitte võtma põhjendamatu riske ja loomulikult seda küll seadus ei kirjuta, aga et üldiselt ettevõtluse eesmärk on ikkagi see, et seal juures veel hoida ka ettevõtet ikkagi kasumlikuna ja teenida omanikule kasumit ka, et see on ka ju loomulik osa. Ja kuidas siis see juhatuse liikme suhe äriühing on? Ma eeldan, et siin võib-olla auditooriumis ei ole väga, enamik ei ole juristid, et see, et ma püüan nagu mitte väga juriidiliseks siin minna, et paragrahve ma ei ole välja toonud, aga sellised olulised momendid, mida tuleb tähele panna juhatuse liikme puhul eelkõige on siis see, et see juhatuse liikme side siis selle ühinguga, mida ta juhib, ükskõik kas on aktsiaselts või osaühing, kehtib ka teiste kohta tegelikult, on see, et üks on siis ametisuhe, mis seal siis tekib selle korrakohase määramise valimise teol ja lisaks sellele võib siis ka juhatuse liige sõlmida ühinguga siis teenistusleping. See ei ole kohustuslik otseselt, aga üsna tavapärane juba täna. Ja see teenistusleping on selles mõttes nagu oluline, et seal saab siis käsitleda ka teatud selliseid vastutuse tingimusi, vastutuse välistamise tingimusi ja näiteks ka kokku leppida ühest küljest võib-olla mingit optsioonides, aga teisest küljest kirjutada sinna sisse ka see, et ühing peab näiteks kindlustama siis juhtorgani liikme kindlustusega näiteks. Ja mis on siis need vastutuse alused ja võimalused, mida siis juhatuse liige kannab, eelkõige tsiviilõiguslikus vaates on tegelikult võimalik 2 jagada, et on 2 suurt vastutuse liiki. Üks on vastutusühingu ees, seda nimetatakse juristide jaoks lepinguliseks vastutuseks, kuna juhatuse liikme ja siis ühingu vahel, mida ta juhib, on lepinguline suhe, ja see on selline põhiline vastutuse liik. Ja samas on võimalik ka see, et mõni ühingu väline võlaosaldaja tegelikult esitab otsenõude juhatuse liikme vastu, kuna seal ei ole tavaliselt lepingut selle võlausaldaja otse siis ühingu siis juhtorgani liikme vahel, et siis seetõttu seda vastutust nimetatakse deliktiliseks, kuna see toimub otse seaduse alusel, et seal ei ole ühtegi lepingut vahel. Ja mis siis on see lepinguline vastutus ühingu ees, et mida see siis tähendab või mis eeldused selleks on siis see, et jah, et tegemist peab olema siis kui see sündmus siis juhtub, kui see kahju siis väidetavalt tekitatakse, peab olema siis kehtiv ametisuhe ühingu ja tema juhtorgani vahel, kelle vastu siis hagi näiteks esitatakse. Teiseks, juhatuse liige on rikkunud juhatuse liikme kohustusi ja need kohustused, need ongi kõik need lojaalsuskohustus, korraliku ettevõtte hoolsuskohustus ja nii edasi, et kõike, kui seda on rikutud ja sellega on põhjustatud ettevõttele kahju, siis tegelikult see ettevõtte või see ühing ise võib esitada nõude siis selle juhatuse liikme vastu, kes on kahju kaasa toonud. Osaühingul on tekkinud varaline kahju või võib tekkida, põhimõtteliselt on võimalik hageda juhatuse liiget ka saamata jäänud tulu eest, mitte ainult otseselt juba tekkinud kahju eest. Jah, loomulikult peab olema kahju ja selle rikkumise vahel põhjuslik seos ja siis põhimõtteliselt jah, et juhatuse liige vastutab siis, kui see kahju ongi põhjustatud siis sellest, et ta järginud siis korraliku ettevõtja hooldusstandardit. Ja kui ta tõestab vastupidi, et ikkagi oli korraliku ettevõtja hooldusstandardist kinni pidanud ja ega me teame, et ega ettevõtja elu ei ole selles mõttes nagu meelelakkumine, et need ohud ja riskid ja kõik need võivad realiseeruda ja kahju võib tekkida sõltumata sellest, et kui hoolikas ettevõtte juht on või ei ole, et me võtame kas või tänase selle sõja olukorra, et väga palju tegelikult see on mõjutanud ettevõtete majandustulemusi ja nüüd on väga keeruline küll siin näha seda, et mõni ettevõtte juht selles mõttes saab süüdistada, et ta ei ole järginud korralikku ettevõtte hoolduskohustust, kui tegelikult mingisugustest rahvusvahelistest sanktsioonidest kaasnevad riskid ja ettevõtet väga palju mõjutavad. Aga see on lihtsalt üks näide. Ja sellise süüvormil otsest tähtsust ei ole, et see on selline objektiivne hinnang. Kas siis ettevõtja või see juhatusliige täitis siis ettevõtja sellist hooldusstandardit või mitte, et seal väga palju sellist tahtluse üle arutelu ei ole. Et vaadatakse, et mis selline samas situatsioonis selline hoolas äriühingu juht oleks pidanud käituma ja siis võrreldatakse sellise standardi vastu, et ei vaadata niivõrd sinna juhatusliikme pähe, et mida täpselt ise ta selle juures mõtles. Okei, ja millised on näited kohtupraktikast, millega me oleme kokku puutunud, et kus siis ühing on ise pärast juhatusliikme vastu hagi esitanud ja kahju hakanud sisse nõudma, on siis eelkõige on need erinevad juhtumid, kui tegelikult tehingud, mida on siis juhatuse liige teinud, erinevad sellistest tavapärastest turutingimustest väga märkimisväärselt ja tekitavad sellega siis ettevõttele kahju, et see vastusooritus võrreldes siis näiteks mingi müügi või ostutehinguga, et kas müüakse liiga odavalt või ostetakse liiga kallilt võrreldes turuhindadega ja sellel oli mingit mõistlikku põhjendust, näiteks kui antakse laenu ja jäetakse sõlmimata mingi tagatiskokkulepe, seal mingi hüpoteek või mingi muu pandileping, käendus jäetakse sõlmimata, et näiteks seda, ega ükski seadus ei nõua, et kui sa pead laenu, kui ettevõte annab näiteks teisele ettevõttele laenu, et siis ta peaks sõlmima sinna juurde veel tagatiskokkuleppe. Samas kohtupraktikas välja kujundatud hooldusettevõtja standard eeldab seda, et kui sa annad teisele ettevõttele laenu, siis sa pead läbi mõtlema ka see, et kui teine pool nüüd võlgu jääb, et kuidas siis ikkagi oleks võimalik seal tagatise kaudu see laen kätte saada ja see on kohtupraktikas tulnud nõue, et kui seda tagatiskokkulepet ei ole ja laen jääb tagasi saamata, siis põhimõtteliselt võib proovida seda kahju sisse nõuda siis sellelt juhatusliikmelt, kes sellise halvasti tagatud laenulepingu sõlmis. Kinnistu võõrandamine alla turuhinna, mis on üsna sagedasti kohtupraktikas läbi käinud juhtum. Osaühingu, ütleme, see on juba natuke võib-olla isegi kriminaalne lugu, et aga osaühingu pangakontot on välja võetud suur hulk raha, mille kohta ei ole ühtegi selget aru saama, et kas seda siis kasutati ettevõtte huvides või mitte. Ja kui ettevõtte juhatus või juhataja ei suuda seda siis selgitada, kus see raha siis läks, siis põhimõtteliselt on võimalik ühingul see raha talt välja nõuda ja niimoodi seda kahju tekkimist vältida. Ja üks suur probleem, mis on õiguslikult keerukas, on tehingud huvide konfliktis, kas siis iseendaga, oma lähedastega, samasugust ärihuvidega, teiste ettevõtetega, et kohtupraktikas on seda, näiteks üks võib-olla selline kohtupretsedent, mis oli, et näiteks tehingu tegemine juhatuse liikme abikaasale kuuluva firmaga loeti selgelt olevat huvide konfliktis ja kui selline tehing toob kaasa või on tehtud turuhinnast erinevatel tingimustel, siis põhimõtteliselt on võimalik siis vähemalt see vahe, see kahju, mis selle tehinguga tekkis, siis juhatuse liikmelt sisse nõuda. Okei, kes kahju nõuab, see ongi see, mis teeb selle võib-olla vaidluse veidi emotsionaalsemaks võrreldes siis teiste tavaliste kahe ühingu vahelise vaidlusega, on siis see, et tegelikult kahju nõuab see ühing ise, kelle juhatuse liige või siis vähemalt endine juhatuse liige siis isik oli, kes siis väidetavalt ühingu arvates kahju tekitas. Ja tõepoolest, kui kohtusse on vaja hagi esitada, siis selle ühingu juht või juhatuse liikme või sageli ta on endine siis juhatuse liige, kes on ka juhatusse tagasi juba kutsutud, siis tegelikult hagi esitab see ettevõte ise või ühing ise. ja tegelikult see vaidlus toimubki siis selle ühingu ja sisuliselt endise tööandja ja siis selle juhatuse liikme vahel. Et ühel pool on ettevõte, teisel pool füüsiline isik ja mis kahtlemata nagu annab oma pitseri sellele vaidlusele ka juriidilises mõttes, et kui ikkagi ühing tavaliselt on finantsiliselt võimekam näiteks finantseerima seda kohtuvaidlust, palkama advokaati ja nii edasi, et seal on jah see aeg-ajalt võib tekkida tunne, et selline Taavet võitleb nagu koljatiga. Et see on kindlasti nende vaidluste iseloomustus ja see on ka selline juhatusliikme jaoks nagu tulevikku vaatav küsimus, et kui kunagi see vaidlus tekib, et siis tegelikult ongi ta üksikisikuna selle ühingu vastas. Ja seal on isegi tegelikult on võimalik see, et ega tegelikult ei pea isegi juhatusliiget tagasi kutsuma, et põhimõtteliselt on võimalik esitada hagi ka veel ametis oleva juhatusliikme vastu. Kindlasti teine asi nagu see, et mis sellest ühingu juhtimisest siis välja tuleb just ärilises mõttes pärast seda, et see on nagu teine küsimus, ja tegelikult on isegi võimalik ja kohtupraktikas läbi käinud sellised asjad, et isegi kui näiteks on, võtame lihtsa näite, et on ühing, kus on 2 osanikku, üks on, ma ei tea, 2/3, teisel on 1/3 seal osalust ja see suur osanik ise on näiteks juhatuse liige ja isegi võib ainujuhatuse liige ja millegipärast väike osanikule jääb nagu mulje, et suur osanik üritab natuke paksemat suppi keeta oma nurgas ja tavaliselt see tähendab seda, et seal toimuvad mingi huvide konfliktis olevad tehingud, mingi osa varast viiakse ühingust välja mingisse teisse selle suur osaniku kontrolli all olevatesse ettevõtetesse ja väike osanik võib tunduda seda, et talle tekitatakse selliste tehingutega kahju, tema omanikuna kaotab, kasum jääb väiksemaks ja mis iganes. Mis põhimõtteliselt on võimalik ka see, et Eesti seaduste mõttes, et sellele väike osanikul on võimalik kasutada teatud õiguslikke võimalusi, et initsieerida vaidlus, kus tegelikult see sama ühing, mis kuulub 2/3 sellele enamusosanikule ja kes on ka juhatuse liige, et ta siiski esitab hagi selle juhatuse liikme vastu. Et põhimõtteliselt see nipp on seal selles, et kui osanikud otsustavad õigusvaidluse pidamise juhatuse liikmega, siis see osanik ei tohi hääletada, kes on asjaga seotud. Ja siis põhimõtteliselt on see, et sellises case'is tegelikult 100% hääli otsustamaks, kas hageda seda juhatusliiget või mitte, on selle väike osaniku käes. Et selliseid asju on juhtunud. Juriidiliselt see võib-olla tundub isegi lihtsam, et eks see konkreetses elus see vaidlus on muidugi keerukas, et ega sellel suurosanikul on siiski väga palju teisi õiguslikke võimalusi seda vaidlust igatpidi torpedeerida ja kas või sellega, et teha keerukaks seal advokaadikulude maksmist sellest kohtuvaidluse finantseerimiseks, aga põhimõtteliselt see on juriidiliselt võimalik. Ja teatud eranditega on võimalik ka siis see, et kui ettevõtte on muutunud maksejõuetuks, et siis see hagi esitatakse ka pankrotihalduri poolt siis juhatusliikme vastu või siis teatud erandjuhtudel ka siis võlausaldaja poolt, kui ei ole siis ühing ise hakanud kahju sisse nõudma, aga need on eelkõige siis juba maksejõuetuse olukorrad, kus ühingust ei ole võimalik otse siis seda nõuet täita. Okei, ja mis siis on see vaidluse üldiseloomustus, mis on võib-olla oluline just selle kindlustuse kontekstis on see, et jah, hagi esitab siis ühing ise ja siis selle juhatuse liikme või siis tavaliselt endise juhatuse liikme vastu ja vaidlus käibki siis selle üle, et kas siis juhatuse liige käitus siis kooskõlas selle korraliku ettevõtja hoolduskohustusega või mitte. Ja põhimõtteliselt tõendamiskoormus peamiselt on ikkagi ühingul, kes siis peab ära tõendama, et teine pool on rikkunud ja seejärel on siis juhatuse liikmele või vastupidi võimalik tõendada seda, et ta ikkagi oli ta käitus kooskõlas kõigi ärieetika reeglitega ja seaduse nõuetega. Ja mis nende vaidluste iseloomustus on, need on keerukad tegelikult õiguslikud vaidlused, väga palju on seal selliseid majanduslikke komponente, et hinnata, et kas mingi tehing oli turutingimustel, kas see oli piisavalt kasumlik ja nii edasi, et tuleb kasutada seal majanduseksperte, et seal ei ole ainult, kui ei ole tegemist muidugi ilmselgelt sellise selge rikkumisega, et ma ei tea, lihtsalt on kingitud mingi lähedasele mingi vara või lihtsalt on sularaha omastatud, see on võib-olla kergemad juhtumid, et aga see, kui seal mingisugused keerukad tehingud, et kas need olid siis või tõid kaasa siis kahju ettevõttele või mitte, on üsna keerukad kohtus pidada. Ja teine, mis on just selle vaidluse iseloomustuse puhul väga oluline, on see, et nagu öeldud, et siis tegelikult ühing vaidleb siis selle endise või ka isegi olemasoleva juhatuse liikmega, nende huvid on selgelt vastandlikud, nad on tülis emotsionaalses mõttes, mõlemad pooled tunnevad ennast võib-olla reedetuna ja siin on nagu see asi, et tõesti see ühing ise, kui on ikkagi tegutseva ja finantsiliselt võimeka ettevõttega, siis loomulikult temal on võimalik palgata selleks vaidluseks advokaadid ja nii edasi. Samas siis see juhatuse liige, tema peab oma siis poolt seda vaidlust finantseerima ise, ettevõtte loomulikult mingit nagu abi talle selleks ei anna ja võite nagu ette kujutada, et tegelikult mõnes mõttes see võib tunduda üsna nagu selline nagu raske ja ebavõrdne nagu võitlus. Ja kui kohtuasi kaotatakse, siis tuleb maksta teiste poolte õiguskulud, isegi kui see võita, siis tavaliselt 100% neid õigusabikulusid välja ei mõisteta, nii et tegemist on üsna nagu ebameeldiva olukorraga, kuhu siis juhatusliige võib üks hetk sattuda. Siis kuna aega vähe, et siis lähme nagu edasi, et teine vastutuse vorm, mida ühingu juhatust või ka juhtivtöötajad võib siis tagada, on niinimetatud deliktiline vastutus otse siis võlaosaldaja ees. Kui üldine see vastutus on selle ühingu ees, mida ta juhib või juhtis, siis teatud juhtudel võib ka väline kolmas pool hakata otse nõudma juhatusliikmelt teatud kahju hüvitamist, mis siin on seotud selle juhatusliikme tegevusega selle äriühingu juhtimisel. Ja see on siis selline seaduse alusel, kahju õigusvastase tekitamise reeglite alusel esitatav nõue. Ma ei lähe nagu palju juriidikasse, et seal lihtsalt see konstruktsioon on siis selline, et on mingi hulk selliseid kaitsenorme seadustes, mis ei ole mõeldud mitte niivõrd siis selle ühingu kaitsmiseks siis selle juhatusliikme kahju tekitamise eest, vaid on mõeldud ka väljapoole. Et mingid normid, mis siis peaksid kaitsma ka neid kolmandaid osapooli või tehingupartnerid, kliente, keda iganes siis selle ettevõtte puhul. Ja ma olen mõningad nagu välja toonud, et mida kohtupraktika on nendeks kaitsenormideks tunnustanud. Üks on näiteks pankrotiavalduse esitamine, kohustus, raamatupidamise kohustus, maksuseadustest tulenevad kohustused, nii edasi, et mõningad näited, et mis selle all mõeldakse. Näiteks pankrotiavalduse esitamine kohustus, et teatavasti on äriseadustikus teatud tingimused, mille äriühing peab ise esitama pankrotiavalduse. Teatud eelkõige selle oma kapital muutub negatiivseks, nii edasi. Ja see on ettevõtte juhi kohustus. Kui ta saab aru, et tegelikult maksejõuetuse seis on vastavalt seadusele nagu välja kujunenud, et siis on tema kohustus esitada. Ja kui ta seda ei tee, pankrotiavaldust ei esita ja astub hoopis mingisse tehingusse mingi teise ettevõttega ja lõppkokkuvõttes see tehing jääb täitmata, kuna siis ettevõte lähebki pankrotti, kas siis mingi teine võlaosaldaja esitab pankrotiavaldus ise ja selle tulemus on siis see, et see leping jääb täitmata ja siis selle lepingu partnerile tekib kahju seetõttu, et see teine pool muutus maksejõuetuks, siis põhimõtteliselt on võimalik see kahju minna sisse nõuda ettevõtte juhilt ja just sellel põhjusel, et ta ei esitanud õigel ajal pankrotiavaldust, sest kui ta oleks õigel ajal pankrotiavalduse esitanud, siis tõenäoliselt seda diili ei oleks üldse ju tulnud ja siis see teine lepingu pool ei oleks ka seda kahju saanud. Et mis veel? Samamoodi raamatupidamise korraldamise kohustus, et üks ka üsna pretsedenti loov kaasus, mis käis Riigikohtust läbi, ettevõte oli jätnud majandusaastas aruandesse märkimata teatud olulised kohustused ja siis vaidlus käiski selle üle, et kas siis see lepingupartner, kes siis seal läks nagu sellesse tehingusse, et kui ta oli tutvunud varasemalt nende majandusaasta aruannetega, et kui seal need kohustused oleksid olnud korrektselt ära üles tähendatud, siis tõenäoliselt see lepingupartner ei oleks sellesse tehingusse läinud, kuna ta oleks aru saanud, et seal on mingid kahtlased kohustused selle ettevõtte juhiga seotud teise ettevõtte ees, mida ei olnud siis kajastatud seal majandusaasta aruandes ja siis samamoodi Riigikohus leidis, et ka raamatupidamiskohustus on selline mitte ainult ühingu sissepoole mõeldud norm, vaid ka väljapoole teiste ettevõtete äri ja ärilisi otsuseid kaitsev norm ja kui majandusaasta aruandes on vead sees ja seetõttu tekib tehingupartneril kahju, siis põhimõtteliselt võib tulla otsenõudega juhatuse liikme vastu. Ja eeldus on muidugi siin see, et see ühing vahepeal on muutunud maksejõuetuks, sest esmalt tuleb ikka hageda ühingut, aga kui ühingult ei ole midagi saada, et siis võimalik minna juhatuse liikme vastu otse ja siis on meil heade kommetega vastuolus olev tehing. Eelkõige siin nähakse kohta praktikas sellist teadlikku või tahtlikku kahju tekitamist lepingupartnerile, et ka sellisel juhul on võimalik neid nõuetega otse tulla juhatuse liikme vastu. Võib-olla kõige rohkem avalikkuse tähelepanu all on see maksuõiguse reeglid, mis on põhimõtteliselt see, et kui ettevõtte juhatuse liige on seal rikkunud ka teatud maksuõiguslikke reegleid ja selle tõttu ettevõte jääb maksuvõlglaseks, siis põhimõtteliselt on võimalik see maksuvõlg sisse nõuda maksuameti poolt ka siis otse juhatuse liikmelt. Seal on need võimalused veel, aga need on siin need enam levinud riskid, mis ettevõtte juhti võivad tabada siis nõuded otse nende vastu, mitte siis tema juhitava äriühingu vastu. Mis on see vaidluse üldiseloomustus, et kui me vaatame praktikas, siis kindlasti statistiliselt neid vaidlusi on vähem, et enamik selliseid juhatuse liikme vastutuse vaidlusi on ikkagi ühingu ja juhatuse liikme vahel. Et see deliktiline vastutus on veidi erandlikum ka ja seda kinnitab ka siis vaidluste lahendamise statistika, aga nagu ikka üldiselt tsiviilkohtumenetluses, et tõendamise reegel või tõendamiskoormus on peamiselt sellel, kes läheb hagema, kes esitab hagi kohtusse ja lisaks sellele, et ta siis peab ära tõendama selle, et tal on kahju tekkinud, ta peab ka näitama, et see norm, mida siis juhatuse liige väidetavalt rikkus, et see oligi mõeldud ka võlausaldajate kaitseks, mitte ainult siis ühingu enda kaitseks. Et see on siis juriidiliselt üsna keerukas, aga põhimõtteliselt neid kohtukaasuse on, kus on ära õnnestunud võita siis hageja poolt. Jälle keerukad õiguslikud vaidlused. Kuidas see vaidlus iseloomustab seda suhet ühingu ja siis selle siis juhatuse liikme või endise juhatuse liikme vahel, et siin otseselt võib-olla ei pruugi olla seda, et see ühing ja siis juhatuse liige, nende huvid on sellises nagu vastuolus või et seal nende vahel käib ka veel mingi oma suur võitlus. Probleem on tavaliselt hoopis lihtsam, kuna see otsenõue juhatuse liikme vastu kaasneb tavaliselt pärast seda, kui ettevõte on muutunud maksejõuetuks, siis mingi pankrotiseisus olev ettevõte, ta ei ole otseselt vaidluse osapool ja kindlasti ta ei ole see vaidluse osapool, kes on nõus finantseerima näiteks seda juhatuse liikme vaidlust. Et põhimõtteliselt on jälle see olukord, kus tegelikult juhatusliige on üsna üksi selles vaidluses. Tal võib olla küll see endine ettevõte, aga see on maksejõuetu ja tal pole sellest suurt abi, eriti kui seal on pankrotihaldur veel vahepeal määratud, et siis sealt mingisugust nagu abi või finantseeringut saada tegelikult on üsna võimetu. Ja teine, mis on probleem ka selle eelmise vaidlusega, selle puhul on see, et ega kõik need tõendid üldjuhul on ikkagi selles ühingus, mitte siis eelkõige juhatuse kohustustes vabastatud siis juhatuse liikme käes ja kui ta üritab midagi tõendada, et ikkagi tema käitumine oli seal kooskõlas mingisugust ärilist huvidega, siis väga sageli on ainult see tema jutt, et dokumentaalsed tõendid on väga raske esitada, kuna need on ettevõttes, kus ta enam ei tööta. Okei, ja päris lõpuks mul on jäänud veel mõned minutid ja ma räägiks ka veidi juhatuse liikme karistusõiguslikust vastutusest, aga me ei lähe ühegi konkreetse kuriteo juurde, vaid just natuke selle võimaliku kindlustuse kontekstis, et mis siis on need eripärad, mis siin võivad välja tuua. Esiteks, kui tsiviilõigusliku vastutuse kontekstis esmajoones on asi see, et vastutab ikkagi ühing oma kohustuste ees ja kui ühing siis ei suuda oma kohustusi täita, et siis võidakse see vastutuse teravik pöörata siis juhatuse liikme vastu, siis karistusõiguses on kõik teistmoodi. Et esmaselt vastutab alati see füüsiline isik, juhatuse liige, kes on siis toime pannud või vähem kahtlustatakse mingis kuriteos ja tänu sellele, et tema on võib-olla seadust rikkunud, siis see vastutus võib üle kanduda ka sellele ühingule, et aga mitte vastupidi. Ja kindlasti põhimenetlusobjekt, kui riik alustab, siis ükskõik kas väärteomenetlus või kuriteomenetlus on see, et uuritakse ikkagi selle füüsilisiku tegu eelkõige, mitte siis ettevõtte kui sellise õigusliku abstraktsiooni tegevust seal mingisuguste seaduslike kohustuste täitmisel või rikkumisel. Et kuriteon on karistatav üksnes või üldjuhul üksnes tahtlik tegu Eesti karistusõiguses. Miks ma selle välja tõin on see, et kui hiljem liigume natuke selle kindlustuse juurde, on see, et see kindlustus sageli ei kata tahtlike kuritegudega tekitatud kahju ja muud asju. Võib-olla õigusabikulusid teatud osas, aga jah, see, kui tuleb mängu juba tahtlik kuritegu, et eks siis see kindlustuse vaates asi muutub kohe juba tunduvalt komplitseeritumaks, aga samas siiski ettevaatamatusest toime pandud õigusrikkumisi puhul see kindlustus võib aidata. Ja näiteks, mis on ettevaatamatusest toime pandud kuriteod Eesti karistusseadustikus, mis võivad kuidagi seonduda ettevõtte juhtidega, niisugused tööõnnetused. Põhimõtteliselt ettevõte ei ole täitnud seal tööohutusreegleid, mõni töötaja saab surma või raskelt vigastada, põhimõtteliselt võib sealt välja tulla ka ettevõtte juhi või vähemalt mingisuguse keskastme juhi ka isiklik karistusõiguslik vastutus, aga see on ettevaatamatusest toime pandud süütegu ja seal põhimõtteliselt kindlustus võiks aidata. Mitte küll karistuse kandmise osas, aga vähemalt selle menetluse osas. Väärteod on Eesti karistusõiguses karistatavad nii tahtlike kui ettevaatamatute tegudega ja neid on, keegi kunagi üritas kokku lugeda, et Eestis on väärtegudeks tunnistatud rohkem kui 1000 erinevat rikkumist, väga palju seondab nende erinevate majandusvaldkondadega, ma ei tea, toiduehitus, keskkonnakaitse, rahapesureeglite järgimine, ma ei tea, pangaduses on neid sadu ja sadu, et põhimõtteliselt ja seal ei ole vahet tegelikult, kas see rikkumine on olnud nagu tahtlik või ettevaatamatu, et seal see karistus võib kaasneda sõltumata sellest. Aga see võib olla oluline selle kindlustuse kontekstis, kuna nagu järgnevalt vast välja tuuakse, et kui tegemist ei ole tahtliku rikkumisega, siis see kindlustuskaitse on tavaliselt suurem. Mis siis selle tulemusena, kui riik leiab, et ikkagi juhatuse liige on siis mingi süüteo toime pannud, sellele kaasnevad siis karistused, olen siin välja toonud eelkõige varalised karistused, rahaline karistus või ka teatud vara konfiskeerimine. Karistus on isiklik karistusõiguses, seda ei ole võimalik kindlustada. Et kui samamoodi, et kui kiiruse ületamisest keegi saab karistada, seda ei ole võimalik kindlustada, et kindlustus maksab selle karistuse kinni ja seda tuleb isiklikult maksta. Aga on teatud osas võimalik siis õigusabikulusid kindlustada nendes menetlustes. Ja need case'id kindlustuse vaates on kindlasti keerukad, kuna mis hetkel siis tekib arusaam, et tegemist on tahtliku süüteoga või mitte, et see ongi viimane slaid, et kas tegemist on tahtliku kuriteoga või mitte, et see selgub alles võib-olla menetluse lõpus. Ja ma olen siin välja toonud, et Eestis üldse kehtib laialdaselt süütuse presumptsioon ja miks on oluline just selle võib-olla kindlustuse kaitse kontekstis on see, et nii nagu ei saa keegi teine isikut lugeda süüdi olevaks enne, kui on siis jõustunud kohtuotsus, ega ka kindlustusandjal ei ole mingit alust öelda, et aga sa panid selle teo toime tahtlikult enne, kui see asi ei ole lõppenud ja päris viimased 2 punkti on see, et kuidas on siis sellistes vaidlustes see ühingu ja selle isiku vaheline dünaamika, kes siis on konkreetselt uurimise all, see sõltub hästi palju kaasusest. Ühing võib olla kannatanud selles menetluses, jälle samamoodi huvid täiesti vastuolulised, ühing võib esitada tsiviilhagi selles samas kriminaalasjas ja kõik see jutt, mis ma eelmistel slaidil rääkisin, tuleb siia kaasa. Ühing võib olla kaassüüdistatav. Põhimõtteliselt omistatakse see sama tegu ka ühingule endale ja mõlemal on kaitsestrateegia sarnane. Iseenesest oli ka välistatud, et advokaadid on nende samad ja sellisel juhul loomulikult see ettevõte vähemalt osaliselt katab neid õigusabikulusid. Aga üldiselt selliste suurkorporatsioonide puhul, mis ma olen tähele pannud, et isegi kui et otseselt ei saa väita, et nende ühingu juhi ja siis ühingu enda huvid oleks otseselt vastuolus selles kriminaalmenetluses, siis ikkagi üritatakse ennast natuke distantseerida. Ja üldiselt ikkagi advokaadid tuleb nendel juhatuse liikmetel ise leida ja siis nende õigusabikulud ka maksta, sest maksuõiguslikult, vähemalt kriminaalmenetluses, kui ühing hakkab katma juhatuse liikme isiklikke advokaadikulusid, need on ettevõtlusega mitte seotud kulu ja vähemalt erisoodustusmaks tuleb sinna juurde maksta ettevõtte poolt. Et see on see elu. Et kokkuvõttes, jah, et kui midagi sellist juhtub, siis on tegelikult juhatuse liige on üsna üksi oma muredega. Et see ühing, keda ta on varasemalt juhtinud, kas on üldse kadunud või on temaga hoopis vastastikku või tema vastas. Ja selles mõttes on muidugi nagu oluline, kui mingid abistavad vahendid seal nagu on ja seetõttu ma ise ütlen ka seda, et Eesti ettevõtjad juba väga selgelt teavad seda, et kui juhatuse liikme lepingut sõlmitakse, et siis sinna tuleb sisse panna optsioonileping, et saada osa kasumist, kui kõik hästi läheb, et aga väga sageli täna veel ei teata seda, et kui halvasti minna, siis need kaitsemehhanismid jäetakse teenistuslepingus sisse kirjutada, milleks üheks võiks olla see, et ühing peab kindlustama ettevõtte juhi võimalikud vaidlused.
Väga hea. Võtan ühe kiire küsimuse ka, et meil on tegelikult küsimusi rohkem tulnud, aga enne kui ma annan lava Indrele edasi, et siis me jõuame ühe kiiret küsida, et kas ettevõtte juhtkonnal on sõjaolukorras ka mingid täiendavad kohustused ja vastutus, et sa paari sõnaga küll mainisid ennist, aga...
Tähendab selles mõttes, et on teatud hulk Eestis õnneks seda ei ole ja ei ole ka veel rakendatud ühtegi sellist sõjaseadust. Meil ei ole eriolukorda, meil ei ole käima löödud veel teatud riigikaitseliste sundkoormiste kohustust, et seda veel ei ole. Põhiline, mis täna on ettevõtte juhtide roll, saada aru ja järgida sanktsioone. See on omaette keeruline maailm, aga see põhimõtteliselt on suur väljakutse. Nii äriliselt kui ka juriidiliselt, et aru saada, et kas on sanktsioon või ei ole sanktsioon ja kui on sanktsioon, siis mõelda välja, kuidas äriliselt ikkagi on võimalik edasi tegutseda.
Aitäh, Normanile. And now we are heading to a very interesting subject because we have here a person who really has been involved with D&O claims for quite a lot of time, and she probably has tens of them on a table, but she will comment herself what she is doing and how she sees D&O insurance. Floor is yours.
And then in credit insurance company COFAS, so almost 10 years of insurance experience. And that's why I'll tell you today about D&O insurance and Lithuanian examples. So how actually we are dealing with those D&O cases. So I'll tell you today, so what are the most typical claims that fall under the coverage of D&O insurance? What usual insured persons, so directors, uses D&O insurance? What the most popular losses are usually covered, and what are the most popular exclusions, how the claims are handling, behind the curtains of insurance, and we will provide you some user guide, so some tips and tricks how to use D&O insurance, how to benefit from the coverage, and some successful D&O examples. So I'll tell you everything in the eyes of insurer, not as a lawyer who represents a director or the company, but usually as a law firm we are retained by foreign insurance companies because they do not have their presence in Lithuania, do not have local claims handlers. That's why we are helping them to handle claims. So we see and we handle those claims as insurers. So to begin with, so why Lithuanian example? Why we need to talk about it? It's because we have D&O insurance and we are using it in the market so for like 10 years already. It's now, I should say, become a quite popular product. We have quite many foreign insurance offering that product. So Lloyd's Market, AG, Chubb, all the big names. And we have some local insurers who are offering D&O insurance, so the companies have a variety of products to choose. and the product can be offered to a very wide range of companies, so from small to large companies are buying D&O insurance. So it used to be, a normal product, companies buying property, general liability, and D&O insurance. So it's not something, it's usual market practice now. And so product is quite well recognized in the market. We have some even court practice. Of course, the product is not so developed, for example, as in UK, but we already have some examples to share. So D&O insurance, how it should be or is understood in Lithuania. So I would say it's a risk mitigation measure at first, and what should be understood, and insurers want that it should be understood like this. This is not the only one risk mitigation measure. It's only one of many other corporate risk mitigation measures, which helps to reduce consequences of liability for the directors. Also, D&O insurance is beneficial for the directors because it provides protection for financial assets. So directors can receive protection for defense costs in case those claims are brought to them. They can receive financial protection for damage. Also, one of the most important benefit is peace of mind. So directors don't need to think what consequences can come from their decisions, but they can focus on developing business and be sure that all damages that may come will be covered by insurance. Also beneficial for companies, the same financial protection, because if companies will need to compensate defense costs or damage for their directors, they can be compensated by insurers. Also beneficial because investors may ask the company to have D&O insurance because some investors sometimes request a seat in the board and then they may require to have D&O protection, or some investors ask the company to have D&O in order to the company's financial assets to be properly protected. And also now, for example, in Lithuania, it's very popular benefit for the companies in attracting new talents, because specialists, they are requiring insurance as the normal package offered to them to start new role in the company. It should be taken into account that this is not a cure for all diseases. So there are insured events, there are non-insured events. So when the product is correctly understood, it can be used to provide all those benefits. So the main aim and core purpose of D&O insurance is it's a mechanism for compensating defense costs. Protecting the director from unjustified claims, and only then D&O insurance is aimed to compensate damage. And is this so because, for example, in Lithuania, we have very low percentage of cases which are successfully against directors. So usually they are ending only by leaving director only with defense costs, incurred defense costs. So, and insured persons. So in Lithuania, actually, the most popular insured persons are definitely CEOs. In the second place, board members. And now, actually, in the recent years, we have more and more cases when, for example, commercial director or other offices are claimed, usually by the companies. We have also many cases with ex-CEOs, when the new manager comes into the company, starting to examine, investigate what decisions were taken by the previous managers, then new claims arises. Also managers of subsidiary companies, also very popular because, when the company obtains D&O insurance, so all the directors of subsidiary companies are also covered. So what are the most popular claims in Lithuania? So definitely mostly we receive and we see claims which are, never mind, it's out of court or lawsuits. So they are claims brought by the company against directors or officers. So the reasons for bringing such claims, they might be any reasons. So for example, selling or buying goods, services, property, shares. So recently we had a case when the company was producing wheat and they sold for the next year's harvest, and the company later brought a claim stating that wheat was sold at a too low price. So director was the claim was around 50,000 of damage. Also, failure on business expansion. So the companies decide, to open subsidiaries in other countries, to start a new type of business, a new sector, and the business fail. So also a very usual type of claims in our market. Failure to initiate insolvency. So in Lithuania, it's a burden for the director to initiate insolvency procedures for the company in timely manner. And also we had a case when the CEO was late to initiate bankruptcy for half a year and received a claim from bankruptcy administrator. They were requesting damage for the company that it generated, for that half of year when the director was late to initiate insolvency. Also using company funds for personal benefits. So the most usual cases, buying cars for the director himself, for wife, for children. So actually those claims can be brought due to any everyday decisions. Not only when the company incurs damage by itself, but when it, for example, had to compensate damage to third persons. So, cyber breach cases are very, very typical example. Or when the company's contracting partners are requiring damage because the director decided to terminate business contract. Also, new trend, I would say so, in the past few years, penalties and fines, which are imposed on the companies. For example, Competition Council, Data Inspectorate Authority, imposing penalties on the companies, and then companies are bringing recourse claims on directors. Also, derivative suits, I would say it's in a second place, in the scale of popularity in Lithuania. So we had such cases when, shareholders can bring a claim against director in the name of the company, for the losses incurred not shareholders, but the company. And the less popular, rare cases are creditors' claims, when the creditors, as third persons, can bring direct claim against director, usually during the insolvency procedures, or state claims. So it's very state claims may become relevant, when the directors now are applying sanction regulations and criminal liability can be imposed on directors. So in that cases, state may claim actual damage directly from the director. So for example, in Lithuania. And employment practice claims, these claims are allowed by the law, but they're still rare. We are expecting them to come in the future. And but what are trends? It's not only in Lithuania, but in UK as well. We are speaking with insurers. So what we are waiting the most, so employment lawsuits. So any type of claims, for example, when the employee disagrees with that he was fired. Cyber breaches, of course. In insurance, we're saying that. D&O claims are coming 1 or 2 years after an issue arose. So if we had, for example, COVID cases a few years ago, pandemic started a few years ago, Now financial reports of the companies of 2021 are now being confirmed. So we are waiting COVID-related D&O claims this autumn or next spring. So the same is with the breach of sanctions. Now directors need to implement the regulation. Nobody understands the regulation. Nobody, yeah, actually, yeah, it's very difficult, you know. But the directors need to take decisions, and only maybe after a year we will see whether those decisions were correct, and then 1 year later we will see new claims coming for the directors due to these reasons. Of course, and investigations initiated, pre-trial investigations and any, you know, supervisory authority investigations initiated against directors, board members, or even employees. So any reasons, and that's where D&O insurance provides coverage, because directors, they do not need to be involved personally in this claims, but at least, you know, they need to be invited to participate in the hearing, interview, to provide certain information, and that's why they need to you know, hire a lawyer, need legal assistance, and that's where D&O insurance provides coverage. So the most popular type of losses, as I mentioned, defense costs, so emergency costs when, you know, for example, director is detained, no time to align defense costs with the insurer, need to hire a lawyer very fast. PR costs, so public relations, when we need to save director's reputation, you know, release some public announcement. Administrative fines are in Lithuania, yeah, very popular, but just to keep in mind that criminal fines are not covered, and settlements. Yeah, so quite usually we, with the help of insurer, we help the company, for example, and director to find, you know, a solution and to finalize the case without the court with a settlement. So a few examples, you know, of the most typical exclusions. So usually those D&O wordings we have from foreign insurance or local insurance do not have very long list of exclusions, but they have many, a few more than you see there, but these I would say the most popular. So conduct exclusion, so it's D&O insurance do not cover dishonest acts, personal profit received by the insured, and criminal liability. And this is general exclusion. It's used in all types of liability insurance policies. And here, as you remember, I said that D&O insurance main core purpose is a mechanism of providing coverage to defense costs. So there is also provided a benefit for directors, because defense costs for the director is provided until his, for example, dishonest acts or criminal liability is acknowledged by the court's final decision. So until that moment, defense costs are covered. Yeah. Also, non-disclosure of pre-contractual information. We have some cases in Lithuania when the companies do not disclose information to the insurer properly. So in order to conclude insurance policy, insurers usually provide proposal forms, ask certain questions to be provided, and you see two examples. These are very standard wording used by many insurers. So one of the questions is about prior claims, whether the company at the moment when concluding proposal form, whether they know about any existing claims initiated against any insured persons. Or the second question, circumstances. Does the company know any circumstances that such a claim or investigation might be initiated in the future? For example, you know, the director already received some oral threats from the shareholders, for example. And Lithuanian law protects insurers, you know, from the consequences if the company do not disclose that information. So indemnity can be reduced, not paid, or the contract can be even terminated. And in this case, yeah, we have some Lithuanian case law which tries, you know, it's not very crystal clear at the moment, but tries to protect insurers maybe in those cases when those claims which were not disclosed in the proposal form were public cases. you know, but still I would not say that, you know, it's very indefinite rule. Also, prior pending litigation, so if the company actually concludes insurance policy, and from the date when the insurance policy starts, so any claims which, you know, were brought earlier, or any investigations which were initiated before the inception of the policy are not covered. So, you know, it's not more as an exclusion, but boundaries of the coverage. Retroactive date, you know, so if certain retroactive date is set in your policy, for example, 2016, so any wrongful acts which were made by the directors earlier will not be covered. And sanctions, so general regulation applies to insurance companies, so no indemnity can be paid, you know, it's come from the regulation. No indemnity can be paid to sanctioned policyholders, so if the company is sanctioned, if directors are sanctioned, or third persons, you know, who are requesting damage are sanctioned, so no indemnity can be paid. So very shortly, how the claims handling process looks like internally, what insurers are doing. So actually, from the insurance side, it looks very easy. It's not a difficult procedure. So insurers receiving notification of circumstances, and then even if the claim is not yet brought, so the insurers anchoring coverage for that circumstances, and when the claim is coming, even if it will happen after 3 years and the coverage will not be valid anymore, so your claim still be covered because you're notified about the circumstances. So insurer starts investigation requiring insured persons or the company policyholder to provide information as much as possible to understand what happened. And then the first decision you will receive from the insurer will be coverage of, confirmation of coverage for defense costs. So the insurer is confirming that everything is okay, so the coverage is valid, and it will compensate defense costs for you, even the claim is not solved yet. And then monitoring the case, communicating, cooperation with the insurer as long as the case is going. And finally, if any claim is satisfied, the insurer is investigating whether the coverage applies, you know, whether there is no conduct exclusion to your claim. So a few tips, you know, for obtaining the insurer. So I will tell a few. So it's very, very important to understand that you need to select an appropriate product. So, you know, coverage is not a standard wording. It very differs. So the company will choose what coverage they want to buy. That's why you don't need to buy and to choose insurance according to the price. Select what you need and ask advice from the broker who knows the best how to understand and read the risks. So disclose, as I mentioned before, disclose full and correct pre-contractual information because it may have influence to your cover. Make sure that the policy provides advancement of defense costs, you know, to receive defense costs without waiting until the claim will be resolved. Check applicable law and jurisdiction because sometimes we see such policies when there is provided English arbitration court, so it will not be very beneficial for the company if there will be any dispute with the insurance company. When you are using the insurers, of course, notify circumstances, not only the claims circumstances. Director becomes aware of any threat notification, email, something, you know, sometimes lawyers write legal opinions where says that director may be subject to any liability for the company's losses, and notify these circumstances to the insurer in order to ensure protection, because the director is never sure whether the company will continue the policy, right? Ask the insurer's prior consent on defense counsel, right? So when you receive the claim, investigation is initiated, so has the insurer to confirm that the right to defense counsel, your lawyer, budget costs are okay with the insurer. Otherwise, otherwise the insurer may have a right to reduce indemnity. Do not admit liability without insurer's prior consent, because it also may have negative consequences to your coverage. And also behave as a prudent and insured. So, there's the rule that insurers like very much, so behave as if you would not have insurers. So be prudent, do everything, and the insurer will not have a reason, to say that you are not performing your duties. When continuing the insurance, so it's a golden rule in liability insurance: do not change the insurer, because there might be certain gaps in your coverage, and if you still need to change the insurer, you're having an offer of much lesser premium or something, consult with your broker in order to avoid those gaps in coverage. It's very important. So, and we still have a few minutes, yeah. So a few Lithuanian cases, so actually simple ones. So those cases were not simple, and they were very difficult for defense counsels who defended directors, but they were quite simple from insurance perspective. And you will see why. So the first case, the policyholder was a construction company, and they decided to expand business in Sweden. But the business failed after a few years, and the company has to compensate director of that subsidiary all the investments the company made during the last year, yes, and because it was their losses. So defense CEO hired defense counsel, insurer agreed to compensate defense costs, and defense counsel managed to agree with the company, actually to provide the company so strong response to the claim that the company finally decided, to finish the case without even going to the court. So this case was quite, it was solved quite in a quite short period, so in a half a year or so. So director, if there would be no insurance, he would maybe not be able to hire such a good lawyers, and the case might have come to the court, and even more defense costs would be incurred in litigating. Second example, so one of the Lithuanian ministries did not agree to pay bonuses for its CEO, but the board actually disagreed with such decision. And when CEO was fired, the board took a decision and paid that bonuses to the CEO. The company then brought a claim, it was a lawsuit directly to the court, against 3 board members, asking to repay that bonuses already paid to the CEO. And the claim actually was not big. It was, around 20,000. But those 3 board members, they were famous politics in Lithuania. And this case was, a matter of reputation. So insurer also agreed to compensate defense costs, and the litigation took around two years or something. And funny was that defense cost was around 100, so 4 times bigger than the claim itself. And PR costs also were quite high, because we needed to rebuild the reputation of the politics. And finally, the case board members won the case in the appeal instance. So eventually, their reputation were reinstated. Third example. State-owned company, which carries transportation of passengers, and they had, fleet insurance. And one person, he was not even a director. He was from commercial department, and he was responsible for obtaining insurance for those buses. And he decided that there are certain 10 buses, for 10 years there were no claims, no accidents, so, and property insurance for those buses very expensive, and he decided not to obtain that insurance. After half a year, one of the driver of those buses suffered a heart attack, and the bus was crashed. Some passengers were injured, so the company had to compensate, you know, including the value of the bus, around 100, and brought a claim against that employee. So he was not even a director. And there also the insurer helped there. So defense counsel were hired then by us to that officer. So because it was employee, his liability was limited. And we, on behalf of insurer, managed to settle with the claim and agree that they will not bring a lawsuit to the court, but we will compensate them 15,000. And what most importantly, we saved CEO from additional claim because, you know, the limited liability of the employee, and then the rest of the amount could be requested from the CEO, which liability is not limited. So we managed to deal with the case, and employee still working in this company, and everything, you know, was solved. And the last case example. So huge construction company was investigated by Competition Council and found guilty. A huge fine was imposed on the company. And then the company decided to bring a recourse claim against the CEO. So the claim was huge, so around 9 million. And at that time, the policy did not provide coverage for any fines. So that's why I was saying that, you know, when you're picking coverage, you need to think what you're buying, because the coverage is not standard. You need to investigate what your company needs the most. And nevertheless, the policy still provided coverage for CEO's defense costs. So the case was quite long, but CEO managed to defend his liability successfully. So he avoided a recourse claim. His defense costs were compensated. So these are 4 examples. So as you see, they are very simple from insurance side, because, you know, insurers are working, their aim is to provide, you know, decision, to provide, to decide whether coverage applies to defense costs, and let the insured and their defense counsels to do their job. Thank you.
Thank you so much. I have one quick question for you. What is usually your role as a lawyer in these claims situations?
So they're called role coverage counsel. So defense counsels, they are defending directors, and coverage counsels are retained by insurers as local claim handlers. So we are like, you know, hands of the insurer, you know, doing everything that insurer would do by himself normally if he had a presence here in Lithuania.
Okay, thank you so much.
Thank you.
And now we are heading to insurance finally. So we have here Peter from Polaris. Some of you might be familiar with Polaris policies, because I can see we have some clients here in the public and probably online also. I think Peter was the first person who actually introduced me D&O as I know it today. So he has done a lot of work with insurance brokers to teach them how this D&O really works and how clients benefit from it. So Peter, here you go.
In Sorainen for an invitation to your great country. You know, we're always very pleased to be back. You know, we've been coming to Estonia for the best part of the last 9 years, but actually I've been writing Estonian business for the best part of the last 15 years, right? And you know, D&O-wise that is, but some of the other lines as well. And I'm actually, you know, pleased to say that, you know, we are seeing a positive, you know, penetration trend, basically in terms of the take-up on the D&O coverage, which is not that surprising for all of the stories that we've heard earlier, albeit I didn't quite appreciate the first presentation because I'm not an Estonian speaker, so sorry, don't have the capability. But we're certainly in very, very unpredictable times with everything that goes on in the world. Of course, the geopolitical situation is, of course, not very friendly to anyone in Europe, but also globally, but also with everything that went on for the last 2 years, basically with COVID, and probably we're going to be facing some more of that post-pandemic headache in the years to come. So all of that is probably a perfect storm from a D&O perspective. So the directors and officers are facing a lot more obligations these days in terms of how they go about business, how they manage it, how they disclose, how they go about themselves. So it will be an interesting couple of years ahead. So I can also tell you that we have got some first-hand experience with Estonian D&O claims as well. So we had some, albeit I'm equally in a position to tell you that obviously we've managed a lot more Lithuanian D&O claims rather than anything else. So, and in fact, you may be surprised, but actually I personally, this is not my company's position, but myself personally, I consider Lithuania to be one of the most litigious countries in Europe. And that tendency is not going away. So we'll probably see some more of that. Yeah. And to my surprise, a lot of that is driven by state-owned companies, which is, generally speaking, in the D&O frame, benign liability, so to speak, but not in Lithuania, as we got to know. So I'll try to just run you very quickly through, some of the main components of coverage and what drives basically the buying behavior, so to speak, because I will basically be able to, kind of put it into perspective from the litigation trends, side. And I'll also tell you, a little bit about the most, interesting D&O trends in Europe, if you like, which may or may not come to emanate basically in this part of the world as well. And in fact, I will be using some of the local examples as well, which have been very widely publicized, so that, it's actually applicable actually for everyone in the room, I guess, and online, right? So. So what's driving it? So why do people buy this coverage, right? So for one, they obviously want to have protection of their own personal assets, as Indrė said, so that drives it. But equally, we like to think from an insurance perspective, we prefer those clients that actually, buy D&O because it's a good standard of corporate governance. We prefer those kind of clients. As soon as there is a personal interest behind it, there can be a moral hazard. Do people know something that we don't know? But, generally speaking, if you have the right level of corporate governance in the company, the investors in the company, the major shareholders, and also the management will be out there to protect the balance sheet of the company as much as their personal assets. Now, why am I saying that? Because, when you have a D&O claim, D&O claims are generally speaking not frequent claims, but they are severe claims. So there's severity. And, they are, it's an operational risk, but I actually consider it's a catastrophe risk, right? Because generally speaking, it will be the CFO and the CEO that will always be subjected to a D&O claim when there is one. And that means they can't focus on their day-to-day job. So from a company perspective, it's bad enough, obviously, that they're facing a D&O claim, let alone if they don't have the financial protection to defend themselves with. So as Indrė said in her earlier presentation, obviously it gives the Ds and Os a peace of mind so that they can go about their business and make actually decisions that they have to make. Of course, we'd like to think that most of them are actually prudent decisions, right? And that business judgment, rules, et cetera, apply. But it's not always the case, and you can't always do it. So if we're looking at it from a Polaris perspective, and I guess from most of the insurers' perspective, we'd like to see that there's a lot more corporate governance-driven D&O purchasing behavior. But there's nothing wrong, obviously, with having the personal assets in mind when you're buying this insurance, because ultimately, that will protect personal assets from the plaintiffs going after it. Now, there's also one other thing that I wanted to highlight very briefly, and I don't want to go into D&O specifics, right? But I will say that, every policy, generally speaking, has got at least 2 sections. And some of them have got 3 sections, depending whether the company has got any securities exposure. And the reason why I'm saying that is what we are seeing, in Estonia, but also in Lithuania and in continental Europe, is that so-called corporate indemnification is not quite something that is very regular, yeah, but it's extremely important for everyone that is going to be buying D&O coverage. Why? Because you have to understand how robust your corporate indemnification provisions are. In very simplistic terms, for those of you that have not come across corporate indemnification or corporate reimbursement, right, it is companies' commitment to pay out of its own balance sheet to protect the directors and officers against the risk of financial hazard, so that they don't have to pay out of their own pocket. This can be very broad, it can be limited by amount, it can be unlimited, so it really depends on what the law allows. So to my mind, and obviously there are lawyers in the room, Estonian law on corporate indemnification is silent. So to that extent, I guess it's probably not been tested, but it's probably allowed. That's what I would probably think. In most of the European countries, other than in France, it's allowed, right? So it's very specifically allowed by law. In France, corporate indemnification is prohibited by law, because French government, and legislators, when they put in place, they said it's a moral hazard basically for the company to indemnify directors and officers. Now that goes against the principle of what the shareholders are actually trying to do when they actually sue somebody, right? So at their forefront will be, what kind of assets do D&Os have? And typically when there is a D&O claim, it's a disastrous of claim. It's a very, very likely a very large amount. And, the only liquid asset that, that's the history basically has proven that to us. The only, generally speaking, liquid asset that directors and officers have is the D&O policy. We have to have a certain standard of financial ratings, so all of the insurers are very well regulated, so they, generally speaking, will have assets to pay out, the defense costs, the indemnification, ultimately the settlement values, or the judgments that basically they're going to have to pay out. So if corporates are not buying D&O, that tells something about a level of corporate governance in a company, right? Because what happens if an investor is going after the D&Os because they've done something wrong, not necessarily criminal, because people generally perceive D&O as a carte blanche for criminals, right? That's not the case, right? So ultimately, if somebody's proven to be criminal in a court of law, we're not going to go into jail instead of them, right? That would have been a nice product, I guess, but we don't have that yet. So probably wouldn't be allowed either. But, we will pay the cost. And, if shareholders that are going after the directors don't, there is no D&O coverage, then there's only personal assets at stake. And our experience with most of the D&O cases in Europe is that when there is a case against a D&O or a CFO or any kind of other individual in his or her role in the company, they are typically assetless when it comes down to it, right? And obviously, it's the assets are either not there or they have been channeled to something else, so that basically the creditors or the plaintiffs don't get easy access to it. So that's why, it's a protection of corporate assets as much as a personal assets, right? So the balance sheet protection. And the way it works, not to lose myself too much into it, but when the company is providing indemnification, we will pay on behalf of the company. So it's a so-called side B claim. If there is no indemnification, we will pay on behalf of the directors and officers. Now, if there is no indemnification, there's one other downside to that for the directors and officers, because typically with brokers and lawyers and whoever else in the company, one of the first questions you're all going to have is, what kind of a limit we should buy, right? So there are certain benchmarks, there are certain more tangible benchmarks for listed companies, and there are slightly worse benchmarks for private companies, right? But you're going to choose a limit. Call it 1 million, call it 5 million. Now, what happens if the claim is for more than the limit of liability that you're buying? And then if there is no indemnification by the company, then you're going back into your personal assets, right? And that's the trouble with not having corporate indemnification. So it's a lot more than just insurance, kind of a protection. So it's, in essence, I would prefer to have very nice corporate indemnification rather than a policy. But, in combination, that's probably, kind of a good fit. Right, so what drives it? So there's different drivers. I shouldn't have put large companies. I think I've said that on Tuesday actually in Vilnius, but it should have been actually, listed companies. So those companies that have got any kind of a securities exposure, whether that's equity or debt, listed on a stock exchange, because generally speaking, those kind of companies have got a lot more disclosure requirements, right? So they're not so much of a black box, as soon as you list, you have to give forward-looking statements, you have to, kind of disclose your financials, you have to provide commentary to it. And generally speaking, we say it's, non-disclosure, it drives a lot of litigation. And in fact, I dare to say this, probably more than 90% of all of the D&O litigation has got something to do with financial misstatements, right? Whether they're negligent or non-negligent, that's a different coverage conversation. But, inaccurate or non-disclosure is a big topic for anyone that's got any securities listed, right? And it's equally a topic for private companies, but we're going more into the regulatory arena then, because it's more with the fiscal authorities rather than anything else. there's a particular kind of a coverage that offers coverage within the DNO for listed companies that will be providing any kind of a prospectuses to the market. So there are three, kind of a levels of that. So, IPO, secondary offerings, bond offerings, and they can also be private placements. So generally, we say in the insurance space, when you issue a prospectus, you've issued a liability document. So anyone that was involved in drafting that prospectus, by the way, that includes our lawyer friends and investment bankers or book runners or financiers or whoever was involved. But primarily, it's the company and all the directors that have been involved or any employees, they've got a liability emanating from the statements in that prospectus. So if anything was misstated and that caused a loss to future, investors or current investors, they can go after them. And we call that we call that risk basically a securities exposure, right? So, and it's kind of more important for public companies rather than private, albeit you do have private companies that issue bond or notes and equally have to, kind of issue a prospectus. Regulatory enforcement is as much of a problem for small company as well as large, or call it publicly listed or private. And it's becoming, I guess, a little bit more brutal, right, in Europe. So there's a lot more regulatory enforcement. We see that because, when you look at the DNO policies, it's very nice, obviously, to look at all of those large cases that I'm going to talk about as well, and that Indrė has kindly disclosed as well in her presentation, where it's demand for damages. But in fact, more often than not, policy gets triggered when somebody, a director or an officer, is invited to a meeting, hearing, or an interview with a governmental body. Generally speaking, regulators. But it can be governmental agencies, it can be governmental enforcement. At that time, you start advancing so-called legal representation expenses, and it starts incurring very quickly, right? And that is the primary driver behind the regulatory enforcement, and people will look at that segment very, very particularly. Not just for the large demands for loss, civil liability, so to speak, but it's actually regulatory liability as well, as much as driving the buying behavior. Cyber events, I'm going to get to that basically probably later down, but that's I've been coming, to this country for quite a while, but, I'll say to you, DNO was always perceived to be a US issue, right? Something that goes on over the pond, right? So it's becoming more of a standard issue. Cyber, however, is a very global issue. So it doesn't matter where a company is based. It can be based in Azerbaijan or in Estonia or in the US. So, you are vulnerable, because we, generally speaking, companies now have access to systems, mobile phones, whatever that may be, and that makes you vulnerable. And, for larger companies, managing of that risk has become obviously a big issue lately, as well as for small companies, because it can be quite a disastrous thing, if you basically can't work and have a massive business interruption as a result of a cyber attack, and you haven't done enough, obviously, to implement, the system of governance in order to protect those attacks. And that's where the liability comes from ultimately. So for smaller companies, the largest risk, or smaller, I call private companies, the biggest kind of a driver is actually bankruptcy, right? What we say in the DNO world is that the insolvency liquidators control the DNO policy. So one of the first things, insolvency liquidators around the world, I'm calling primarily the Western Europe, like UK, Germany, Spain, Italy, one of the first things they're going to look when they come into the company is the DNO policy. They will try to go after it very quickly, and because there's probably, not always is the case, but probably something has gone wrong with managerial decisions so that the company has ended up in bankruptcy. And for insolvency liquidator, insolvency liquidators have to fill, I'm not sure what the right word is, but they have to fill the liquidation mess. So they have to get assets from everywhere they can take it from. Otherwise, they're in breach of their own professional fiduciary duty, right? So they have to do it. And, very often a bankruptcy leads to a full limit loss under DNO policy, no matter what the limit is. So that drives it for private companies. I think, Indrė, you mentioned, so employment practices claims are not that uncommon, right? Whether that's for discrimination, any kind, discrimination, for wrongful dismissals, deprivation of career opportunities, and so on and so forth. Generally speaking, employment practices claims are not massive claims, so I couldn't really class them as severity, other than if it's a securities action, so if it's a collective action. And there are cases in Europe where you've got collective actions that go, generally speaking, after the company. Every now and then they go after managers as well for that. So regulatory enforcement, as I said, and cyber events are a big driver also for kind of a private companies. And that thing will stay with us for a long time. So who are the most frequent plaintiffs, right? So Indrė already mentioned, company. In most of Europe, company is going to be the primary driver of civil liability litigation, so demands for damages, because the fiduciary duty of directors and officers is owed to the company, right? Not directly to shareholders. But actually, around the world where security class actions are actually allowed, I would put shareholders and company in the same box because they would, generally speaking, have the same interest in going after the Ds and Os. If you would be looking at European litigation, probably I dare to say this, I don't have the statistics, so the last one was published in 2004 and it's not adequate, right? But ever since we didn't have this survey done again. So more than 80% of all of European D&O claims are regulatory enforcement. So it's the regulators that go after Ds and Os. But the largest claims, but the smaller volume claims, are claims by the company and the shareholders. So those we call severity claims, right? So they will be, generally speaking, they're not going to go after a director for 5,000 euros, but they will go for directors, if the balance sheet has been eroded and shareholders' equity has been eroded, call it by 1-2%, right? That's when, the large losses happen. Insolvency liquidators, I've already mentioned that. Employees, I've already mentioned that. Creditors are an interesting thing, right? So via insolvencies, but it can be also via non-appropriate disclosure at a time when people were after funding. And competition is very rarely in Europe. If there is competition claims, so that means a competitor of a company will go after the directors and officers of that company, it will, generally speaking, be for IP infringement. There are some very big cases in Europe for that, but they are very rare. But they're very complex at the same time. So what goes on in Europe? Company claims are a very big standard, right? Because, generally speaking, the directors and officers, owe the fiduciary duty to the company. So those are being pursued regularly. If you look at countries like Germany, there's a lot of D&O litigation by the company. And when we're talking about company, I've specifically said insured versus insured. That means that one insured person, which can generally speaking be supervisory board members, will go after the board members. So it's so-called internal claims. In insurance space, we call them 1v1 claims, and they are quite frequent. The collective redress, most of the countries, don't quite dare to say what's happening in Estonia. So maybe the colleagues from the law firms will maybe be able to give you more of an insight. But, there was a requirement by EU that European countries implement some kind of a collective redress, primarily driven by consumer actions. But, they give, the basis for securities actions as well, which are, as I said, probably the most interesting ones in terms of the quantum of claims. Regulatory scrutiny has increased. All the next three boxes are probably in the same arena, but I wanted to highlight that people get very excited about environmental, social, and governance, right? So that's kind of one of those modern topics. It's getting very important, with everything that goes on in Ukraine, with everything that goes on with the environmental change, with everything that happens with COVID-19. So all of that, is driving it. In fact, Estonia has got quite an interesting dynamics in terms of anti-money laundering breaches, right? So there's a big scandal in this country. So I'll get to it in a moment. But obviously that is important from a litigation trend perspective, because in Europe we're seeing a lot of regulatory enforcement in the space of AML breaches, and regulators are very, very focused, especially because what goes on in Ukraine and all of the sanctions basically that are relating to Russia these days, and some of the other countries around. So the post-pandemic uncertainty. So, there was a lot of governmental money being floated into businesses, in the last 2 years. That has widely stopped. I'm not sure what the situation is here in Estonia. But what that means from insurers' perspective is, we are very likely going to see, with what Indrė said, about 2 years down the line. In fact, we call it, in general terms, it's anywhere between 3 and 5 years. We call this period discovery, right? When do the companies discover that something has been done wrong? And I actually think, the post-pandemic world will turn upside down, when some of the companies that have not been sustainable even before COVID days were staying alive because they had governmental funding, and we'll then see, a flood of insolvency. And we're actually quite cautious on that note. So financial health of companies is very important for us. So I've taken that from from an interesting article by the Financier Worldwide, and actually it's a good question, right? So there's been, back in the day when we started basically going out and meeting clients in the early 2000s, in Central and Eastern Europe, people didn't see much liability, so they sat on boards or supervisory boards, and because it was it was good for their profile. They didn't mind how much money they're earning for the privilege, and they didn't really, I would say that they were not really aware of their liabilities, right? Were they really aware that, you know, they are liable with all of the personal wealth? Because I think in Estonia, there is no limitation, you know, financial limitation for board members, you know, so there, if you get sued, you can get sued for unlimited amounts, right? And there's a question, you know, about this one is, you know, why do people not buy D&O more frequently? It was readily available in the market. You know, the pricing has obviously increased in the last couple of years a little bit, but, you know, I still think it's very affordable. And in combination with corporate indemnification, you know, I think directors and officers will do themselves a favor, basically. So I'll skip that. I've already talked about that. Obviously, I've talked about the 1v1 claims. Now, this one is an interesting case. I'm not sure whether you've come across it, but it's in your very near vicinity. Obviously, it's a Polish case, right? And it just gives a little bit of a trend emanating from ESG, from environmental, you know, and governance. So there was a not-for-profit environmental organization that was at the same time a shareholder of a company called INEA. I'm not sure to what extent you know it. I mean, I didn't quite hear about it before, but it's a very large power utility, right? And they basically voted, you know, at the AGM to invest 1.2 billion euros into a new coal plant called, I think, Ostroleka, something like that, yeah? And this environmental law organization, you know, consumer organization, has basically sued the company and the Ds and Os, and has basically reached in the district court ruling the annulment for the investment. And they said that basically the board didn't take sufficient amount of consideration basically to the environmental implications, and also it was financially unjustified at a time. That's what the court ruled to as well, because, you know, the environmental carbon coupons are very, very expensive, obviously, for anyone that is basically polluting, right? And it was financially unjustifiable because there's alternative renewable solutions in the market. And they said that the board didn't give it enough consideration, so it was annulled. But it's a 1.2 billion investment that basically has gone down the water. We will probably see more of those kind of, you know, litigation down the line. You know, again, you know, people have got some other issues at the moment, you know, to do with geopolitical tensions, but we will see more of the ESG litigation down the line. AML breaches, I guess the last one, we probably don't even need to talk about that one, but obviously, you know, any kind of a systemic or non-systemic anti-money laundering breaches are a big issue from a D&O perspective. You know, we will have to defend those claims for a very long time, you know, and we are quite focused basically, you know, so the whole financial institution sector is very, you know, kind of it's in a very contained, very contagious environment, so to speak, because, you know, directors and officers have to give it a lot of consideration so that there is a system of checks and balances in the company so that AML breaches don't happen, basically. They must not happen, right? But it happened. And to my mind, actually, the ePay block is actually not the only fintech in Lithuania that was where the license was revoked because of the anti-money laundering breaches. The Danske Bank scenario, I'm not sure what goes on in that space. I wouldn't even dare to say, but, you know, there were articles in the media domain about the Ds and Os being held liable for what was going on a board level in their parent company. GDPR, I can't really comment on any of the GDPR D&O European claims. I can tell you there's an interesting place actually in the US. It's a US company, but basically the shareholders of that US company are suing the Ds and Os and the company for the apparent reckless disregard as to readiness for GDPR implementation, right? They were always giving assurance to, you know, kind of in the public domain to the investors that the company is fully ready and prepared for the GDPR implementation. And actually, you know, as the shareholders are saying, you know, the company was not ready for it, right? And that is a failure to supervise, you know, and it, you know, when you hear insurers, the D&O insurers talking about failure to supervise can be many things. But one of the things is that, you know, the board members have got an obligation, or sort of the whole management, you know, when I'm talking board is both boards, if you like, and the executive level. So they've got a duty to supervise those that actually perform the business, so to speak. You know, so if you're in the professional services industry, you know, the board has got a duty of oversight and put the right controls in place so that breaches don't happen. And GDPR, I think we'll see more of that. To my mind, it can be cases like this where the companies have publicly stated that they are ready, and maybe they're going to be proven not to be ready. And the second level of GDPR litigation that we can see, it's derivative. So derivative because of the fines and penalties that are going to get imposed as a result of those breaches, and they can be quite heavy, right? So they can be quite literally in the millions, and I think it's the 4% threshold, right, of the consolidated revenue. I think something like that. So that can be big for big companies, and we'll probably see more of that. Cyber, as I said, that's a systemic issue. You know, we consider it as a systemic sideways exposure. So, you know, cyber attacks are not limited to one country, one industry, you know, a particular country, you know, so it's basically the whole world is actually exposed to cyber attacks. And if the companies fail to implement the right system of controls in place, checks and balances again, you know, they could be held liable for cyber exposure. And in the US, there are at least 3 securities class action tried at the moment, which are based actually on security breaches, you know, Target being probably the most prominent one really of all of them. So the last slide really that I have for you, prepared for you today, is really the post-pandemic. And, you know, this is purely, you know, Polaris' opinion as to what's going to happen. We don't have a crystal ball, but, you know, we have started seeing the rise of insolvencies. You know, they're slowly picking up. And recessionary exposure, every time when you're going to look at how the D&O market has evolved, you know, as you probably know, the first D&O policy was issued by Lloyd's in 1933. Why in 1933? It was after the big crash, right? Every time when there's economic volatility, there's a pickup in demand of D&O, right? Because when people are pressed against the wall, the litigation is probably more often, right? And, you know, if you're going to be seeing the larger spikes in the early 90s, in the early 2000s, at the end of, you know, post-Lehman, you know, there was an increase of D&O policies. We see that there's probably a very large flood of corporate insolvencies on the horizon, not immediately, but, you know, I give it next 3 to 5 years when we're going to actually see that tail basically spiking. From a D&O perspective, that is an interesting evolution, you know, so we're going to have to all be careful. But equally for directors and officers, the inherent risk of today being very liquid and tomorrow being, you know, bankrupt because of, you know, things that you can't really control is probable in the next couple of years. Thank you very much.
I have one question also from online.
Sure.
So, yeah, as Indrė previously mentioned, this is mostly or firstly about legal expenses. How and to what extent is legal expenses will be covered under the D&O policy?
Very good question. You know, probably the most frequently paid claims are legal expenses for, you know, whether that's defense costs, but don't forget the regulatory arena. So, you know, and sometimes regulatory arena is actually more, it's more expensive. Policies they're constructed differently, but they all have the same analogy. So legal representation expenses in a regulatory enforcement or governmental enforcement is, generally speaking, full limit of liability. Depends on the limit of liability you have, right, I guess, as to how long this is going to last. It can be very expensive, especially with multi-jurisdictional regulatory enforcement. That's when they get extremely expensive. And, you know, sometimes board members will have conflict of interest. So what that does, it's a multiplier effect on the cost. So everyone has their own representation in multiple countries, you know, and then there's a part of uncovered legal representation expenses which has to be set. So the corporate, you know, the legal entity will not get the benefit of legal representation expenses in a regulatory enforcement side, but individuals will. Generally speaking, full limit of liability. Yeah.
Thank you so much. Now I ask Peter, Indrė, and Norman to join me join me here, and we will look some cases from Estonian market. These cases are from the media we have collected, so you can guess who's the company. We have not given you any names, so you can test yourself. Maybe you can guess who's the company. But the plan here is that Indrė and Norman can give some short legal opinion about these cases, and Peter will discuss with us how would D&O insurance respond in these cases. So let's see what we have. The first one is about the machine engineering company, whose executive were accused of cheating millions, and they are blaming their employees about like losing this money. So what do you think, Norman?
Yes, thank you. It's working, I
Yeah.
think.
Yeah.
Or not? Okay. I changed the mic. Okay. Yes, thank you. Just for introduction, yeah, they are real life cases, but they are kind of real life cases. We have changed up a bit just to more bring into light more the problems from this insurance angel. But yes, this is from the legal perspective. What's the problem here when we are talking about the liability of board members? Yes, there can be a criminal investigation because there are hints that this cheating money from the banks, it can be a fraud, and yes, the prosecution office or police can initiate a criminal proceeding against those board members. That's the one. Another thing is that actually the bank alleged victim of this fraud actually can bring the direct claim against those board members, because if it is a fraud, it's from the civil law perspective action against the good moral, and in those cases those third party can bring the action against those board members directly. But of course it's the strategic choice who to blame or who to claim, because maybe from the strategic choice point of view, it's wiser to go after this company, not the board members. And the third thing, of course, if this is true, what is claims, actually these companies or this company can also bring the action against those board members. So, but that can mean there can be three different proceedings. One criminal investigation or a trial, and two civil proceedings against those board members. And what is also important from the point of view of DNO, I think that those board members claims that they are not guilty at least, or they behave according to the standard of the board members. So it's not intentional. At least they are saying that it wasn't an intentional causing of damage, or it wasn't intentional fraud, at least. So.
But can it be that board members say that we don't know nothing and live happily ever after?
Of course, they can say, and they usually do that, but I'm not sure that they can live happily after that, because claimants and prosecution service don't believe usually such a words. Okay.
So to manage everyone's expectations. So if it's proven to be criminal at the end of the day, that's not what the policy is designed to pick up. Now, what the policy is designed to pick up is that it assumes that the D's and O's are not guilty until proven guilty. So that's the American concept, right? So so we will, in instances like that, generally, you do get excited about, because of the quantum. I mean, 20 million is a huge amount of money, right? And from a DNO perspective, you get excited about two things. So you're going to have to defend those directors. In civil proceeding, probably there's going to be a civil proceeding next to the criminal proceeding, and obviously defend them in a criminal proceeding as well. It gets exciting because a lot of cases like this one, sometimes the dynamics change, and sometimes they've not been fraudulent. Sometimes. And sometimes, you want to make the case go away. Directors and officers, when there is a case like that, it attracts a lot of media attention. DNO carriers, so ourselves and lawyers, we like to work under the radar screen. So the D's and O's don't need much publicity, and sometimes cases like that get settled if there is a civil element to it. Obviously, if it's proven to be ultimately fraudulent, it's kicked out. Now, one of the other things that is quite interesting for a case like that, there are of course quite a few in Europe, is the dynamics with the company. So European claimants are we shouldn't really underestimate anyone. So, they will go after the deep pocket as much as the individual. So they're going to go after everyone. And cases like that are, generally speaking, very costly because kind of it says cheating from the banks, right? I'm not sure quite what that means, but probably it's got to do with something very complex that will have to be investigated by independent third parties, forensic reviews. All of that is a lot of cost. So I'm not sure what the cost allocation looks like in Estonia, who has to pay those costs, but it will be very likely very expensive for the company, and DNO carriers will very likely need to participate a considerable amount until this is fully tried. Yeah.
Thank you so much. I think this is quite clear that a lot of different parties are involved in this case, and DNO will respond. Okay, let's see what's next for us. The head of an oil transport company bribed a senior employee of a state railway company. So the amount of bribery was 170,000, and he pleaded guilty and was sentenced to 2 years in prison with additional fine. So I think this is a case for you, Norman, as you're a specialist here.
Yes, thank you. Okay, I hope this is working now. Somehow it's quite simple case because it's a crime, it's a bribery, and usually those bribery cases they should not be related to any damages actually and nobody is seeking civil remedy usually with those investigations or related to those corruption investigation. But what was it's as I said, it's a kind of real life case, but and DNO was related to this case. And what was interesting or problematic from insurance point of view, this last point, this accused person pleaded his guilty and admitted that yes, I did it. And in Estonia, we have just to my colleagues from Lithuania and from Austria, that we have in Estonia so-called settlement procedure also in the criminal proceeding. It's a kokkuleppemenetlus. It's in Estonian, and it's a very short proceeding in the court, and it's not full trial. And before this settlement procedure in the court, the prosecutor and defense lawyer and this accused person, they signed the settlement, and this particular person pleaded himself guilty. And the end of the day, it was a problem from the insurance perspective because it was he wasn't denied to the bitter end that I'm not guilty, but he pleaded himself guilty, and that was the problem from insurance point of view. Should pay defense costs or not after pleaded himself guilty.
So Peter, what do you think about it?
Again, much like the first one. So in fact, I apologize. So I actually, whenever we speak to our colleagues in London, I always tell them that we write a lot of Estonian DNO because it's the 7th least corrupt country in the world. But now we've already got like 2 crime cases. So I'm like, I'm going to probably start running soon. But I actually, from our point of view, of course, it's much like the first dynamic, right? So we wouldn't obviously pick up coverage after somebody has actually admitted that they've been fraudulent, right? I mean, bribery, corruption is on the other side of the law. Probably wouldn't even be able to pay, even if we wanted to pay, really, because it's probably illegal, I guess. I see a bigger issue. I mean, obviously the defense costs, probably going to be quite costly on something like that. Maybe not. Obviously, if it's a short proceeding, then probably it's not going to be that expensive. I'm not so worried about the amounts. Now, I think one aspect of this one, which is interesting, it could be, I'm talking purely about what could be and what generally will be, call it Western Europe, in continental Europe, but certainly in any Anglo-Saxon world. Something like this will lead to a case which is a derivative case of this. It will be a civil proceeding because, there's a lot of loss of goodwill once something like that happens. Companies where this happens, it will be a market share drop, it will be a lot of loss to shareholders that, the amounts here are significant, But that's not the biggest problem. So I think the bigger problem is the knock-on consequence of any D&O litigation that comes as a result of this. And, you know, you could have a senior employee, but hey, how about the board? You know, have they put the right procedures in place for something like that not to occur? You know, do they have any liability? You know, so it's a knock-on effect. You know, call it if it's a listed company. When this comes into media, I would not be surprised if share would drop by 20-30%. You know, that's a loss to the shareholders of the company as a result of wrongdoing, of wrongly implemented procedures in order to prevent something like that. So I think that's where I would get more excited about this. Yeah, but the defense costs certainly something like that. Yeah.
Mm-hmm. Thank you. Yeah, this shows clearly that even like small or clear case can become D&O case like very easily. So let's see then another one. Yeah.
Very last remark to this previous case actually, and as I said actually, this board member had insurance D&O insurance, and what was the problem? Actually, it was that during these proceedings. Of course, it was quite obvious defense tactic to make a settlement, and it was also advice from his defense counsel. But what's the problem? It was not negotiated previously with the insurer. And that's also a very important thing, that if you are going, if accused person, or it's not should be accused person, it can be also civil litigation. If you are going to settle the case, it's necessary, I think, to consult with your insurer as well before that.
Very good. Let's take another one. I think I will give this case to Indrė, but I read briefly what it is about. A board member of a real estate developer did not file for bankruptcy in time. And there was, of course, real estate company with market value decreased. So, and creditors who claim are unsuccessful in bankruptcy proceedings and brings an action directly against the board member. Indrė.
Thank you. It's working. So, I think I'm not will be very can comment on the liability question, so I can comment from the insurance point of view. But we have actually, as insurance lawyer, we have many similar cases in Lithuania as well. So only there is a burden for the director to initiate the bankruptcy in those cases. So actually, they are also quite similar, from insurance point of view. So requesting coverage from insurer for defense costs and defending liability of the director in order to prove that director did everything he needed, and that the time to initiate the bankruptcy have not yet come. So and also coverage for board members in Lithuania would be directors should be valid in this case. So I would not see any real issues from coverage point of view, actually.
Yeah, this is like a classics of
the
D&O.
very classic.
Very classic. Yeah.
And quite simple one, actually. Yeah.
But expensive.
Yeah.
Yeah. I noted that sometimes. Yes, I noted that sometimes in the offers the bankruptcy or insolvency issues are excluded. Is that so? I've seen that like lately. In the
So how about insolvency, and how is it and when it's excluded?
Yeah. Good question. Thank you for this one. So obviously something like that is a breach of fiduciary duty, I guess. So there's probably going to be liability there. But insolvency exclusion, it's not a systemic exclusion. It's only imposed when we are talking about severely distressed financials of the company, right? So I can talk about Polaris. I can't talk about my peers, in the market. But we do not have an insolvency exclusion as a systemic exclusion on our products. It's not viable. We have to underwrite, right? But if we see that it's a distressed risk, financially distressed risk, that could be a conversation, right? We wouldn't impose it systemically on every single risk. It is a I will say this, very openly. An insolvency exclusion is a massive prohibition on the coverage. It's not a good exclusion. So companies that have that, there's probably a very good reason why they have it, right? So they've probably gone into the market too late. They have not had D&O before they were financially distressed. And, we see the analogy, D&O is one of those things in continental Europe where it's post-event buying. That's too late. You're gonna get apologies for the words, but you're gonna get penalized for that. And there will be huge premiums. There is gonna be coverage restrictions. Because people will not want to take that moral hazard on board. So that's, But insolvencies are a very frequent thing in Europe. Very frequent. Let alone in Anglo-Saxon countries. But in Europe, they're very frequent. Yeah.
Thank you. So this is where I can see you impose sometimes these insolvencies, like if it's like very risky and new company, and if this company is already on the way on financial distress. So this is like where we have to consider that such exclusion will be applied. So the next case is property maintenance company who is exploiting its foreign employees, especially Ukrainian. They were working like 300 to 400 hours per week. Clients had no idea. Competitors had some idea. And we know that such thing is punishable by law. Both like legal person and physical person can be fined. So, Indrė, you want to take it, or Norman?
So, as I can comment from insurer, so Norman, if you can start, and then I will continue.
Okay.
Yeah.
Okay, let's do it in this way. Yes, it's a kind of real life case again, and happened recently. From the legal point of view, yes, it can be a misdemeanor according to the Estonian law, and government agencies can investigate such kind of case, and this is in Estonia, this is a criminal liability of the company and also the board members or those employees who are responsible for those decisions. It's not so severe as ordinary crime. It's much less, but as I explained in my last slide, the first attacked person from the government body is board member, and the second additional can be company itself. So that's not the problem, but that's the reality of all those investigations in Estonia, that the first target of those investigations are physical persons. And what is, again, one differentiates from Lithuania, I think that, and also what Peter explained, those administrative fines and any other fines ordered by the government agencies. In Estonia, we don't have such administrative fines. We have only criminal fines. And even if the thing is not very big, it's a misdemeanor according to the law. But yes, the penalty should be served personally. So it can be, I think, according to my knowledge of Estonian law, it's not possible that insurer will pay this fine, even if, for example, it's not very hard, maybe 100 euros or 1,000 euros, but the insurer cannot be paid for that. But of course, the legal cost can be borne by insurer. Yeah.
But how about clients? Can they claim something?
I think that clients, maybe those Ukrainian employees can, because they are victims of this wrongful act. But of course, they are in very vulnerable position to do that. That's the problem here. Why the government agencies should take the case over and investigate this as misdemeanor.
So that's where the difference comes, because in Lithuania we have totally different situations. So in similar cases we mostly have administrative cases which most often are insured by D&O policies. In very rare cases we have exclusions. So, but what relates with the criminal cases, so definitely no insurance coverage can be provided, but defense costs will be compensated until the criminal liability will be acknowledged by the court. And if there would be any civil claims, and whether if they would come from the dishonest acts, so it also would be excluded. But if the liability would not require to acknowledge dishonest acts, for example, gross negligence, so in that case, coverage should respond.
Okay, Peter, what do you think?
So, couple of things, I guess, here. So, by the way, I'm Slovenian by background, if that helps anyone in understanding what I'm going to just say. So, we have got a collective action system, especially for employment practices, that is long before the collective redress was introduced for security actions and so on. So, an interesting question here is if collective actions by those disgruntled employees are possible. They will very likely go against the company, but they could go against the Ds and Os if, harassment, I'm not sure how and mobbing and stuff like that, I'm not sure how this is deemed according to Estonian law, whether it's criminal, whether it's civil, I wouldn't really know. But, one of the things that it's good that I've got the opportunity to discuss, obviously, with the Estonian, corporate domain, is, people get very excited about fines and penalties. We generally speak, I personally, I really don't believe that should drive the D&O coverage, because there are a lot more important issues than fines and penalties, right? And secondly, fines and penalties in a lot of jurisdictions, not in Lithuania, as you said, Indrė, right, are not insurable by law because they're against public interest. But obviously something like that could well turn out to be multi-jurisdictional again. I don't know where the abuse happened, was it offside, was it onside, or whatever happened, was it in this country, another country. But, in some countries around Europe, fines and penalties are fully insurable by law, like in Lithuania, not criminal fines. But if it's a civil, we call it administrative fine, right? As a result of a misdemeanor proceeding, you can possibly get coverage for that. So that could be. But there will be, again, legal representation, expenses will be paid out, the defense costs are going to get paid out. And if ultimately, it's a civil proceeding emanating from this, you may have to pick up the judgment as well, or the settlement amount, if there is a knock-on litigation, I guess.
Thank you. So general rule is that fines and penalties are not covered, but everything related or going on around this case can be covered under T&O. So unfortunately, we are now out of time and we can't take any more cases. But it has been a pleasure doing this seminar with you, and I hope people in this seminary room and online enjoyed it, and I hope they have many questions so we can respond to these after this seminary within a couple of days maybe, or next week, let's see. So please don't hesitate and send this over, and big applause to Peter, Norman and Indrė. Thank you.